My question is, you're a law professor. You've been an appellate advocate. As a judge, one day, if there's a Democrat in the White House, you may be a judge. That wouldn't surprise me at all. Would any judge have a basis for signing an order with zero evidence and saying, the court finds? Is that consistent with the judicial oath, yes or no, assuming the hypo of no evidence?
That was a very revealing exchange, and in my view, Senator Ted Cruz was absolutely right. He cut through all the legal jargon and asked a simple question. How can a judge sign an order claiming there are reasonable grounds if no actual evidence was presented to support it? That is the issue at the center of this discussion. Professor Vitiello tried to defend Judge Boasberg, but after being pressed repeatedly, he ultimately admitted that if the Department of Justice provided no evidence, then signing the order would be inconsistent with the law. That is a major admission. If you believe judges should be held accountable and required to base their decisions on facts, not assumptions, be sure to like this video, subscribe to the channel, and let me know your thoughts in the comments.
Thank you, Professor Vladeck. I would note you're a very talented law professor and appellate advocate, and you said, gosh, Judge Boasberg followed the law. Well, he plainly disregarded the law regarding non-disclosure of senators, subpoenas targeting senators, but set that aside. Your defense of him is he didn't know. Well, if he didn't know, that's because Jack Smith was engaged in wild misconduct by not telling the judge. But apparently the judge didn't give a damn because he didn't think to ask. But let me just ask you, did Judge Boasberg have any factual basis whatsoever to sign multiple orders that says the court finds reasonable grounds to believe that such disclosure telling the senators will result, not may result, will result in the destruction or tampering of evidence, intimidation of potential witnesses, and serious jeopardy of the investigation? And I would note to you that the claim now is he didn't know who the hell it was. So did he have any possible factual basis other than a brooding animus to all Republicans and that all Republicans are criminal? Is there any other conceivable basis?
Senator, I haven't seen the government's application. Perhaps you have, and I don't want to risk delving into areas that are confidential. But without having seen the government's application for the NDO...
You're very clever. What do you think?
I mean, I can speculate that there was very likely information in the application, given that the grand jury agreed to issue a subpoena.
All right, assume for sake of argument there was no evidence, because Jack Smith said, I didn't tell them they were senators, so you're leaving out a lot of details. So assume, this is a hypothetical, you've argued in court many times, the hypothetical is the Department of Justice told him nothing. I believe that hypothetical to be true, but assume the hypothetical. Is there any basis for signing these orders over and over again without the judge saying, gosh, can you give me one piece of evidence before I sign this order?
So, Senator, you're asking me to answer whether the Justice Department provided no factual proffer and he approved the application.
No, I'm saying if DOJ provided no facts to support this, would Boasberg have any basis for signing it without any factual predicate whatsoever?
I mean, I think the question would just then become, what was the standard practice? And on that regard, I would defer again to the letter that
I don't care if the standard practice is to be lawless. My question is, you're a law professor. You've been an appellate advocate. As a judge, one day, if there's a Democrat in the White House, you may be a judge. That wouldn't surprise me at all. Would any judge have a basis for signing an order with zero evidence and saying, the court finds? Is that consistent with the judicial oath, yes or no, assuming the hypo of no evidence?
If the Justice Department had provided no evidence in support of it, then I would think that an order that nevertheless approved it would be inconsistent with the law.
I do as well. Senator.
Main reaction body. Ted Cruz did exactly what lawmakers are supposed to do. He asked direct questions and refused to accept evasive answers. The core issue here is straightforward. When a judge signs an order stating that disclosure will lead to destruction of evidence, witness intimidation, or harm to an investigation, that is a factual finding. It should be based on evidence, not speculation. Cruz's argument was simple. If the Department of Justice offered no factual support, the judge had no legal basis to sign the order. Professor Vitiello initially tried to avoid the question by saying he had not seen the sealed filings. That is understandable, but Cruz removed that excuse by presenting a clear hypothetical. Assume there was no evidence at all. Under those circumstances, could any judge lawfully sign such an order? After some hesitation, the professor acknowledged the obvious answer. No. And that is the key takeaway. Either Jack Smith's team failed to provide the judge with the necessary facts, or Judge Boasberg signed the orders without demanding proof. Neither possibility is reassuring. Cruz was also right to reject the idea that standard practice makes this acceptable. If a practice ignores the law, then it should not be defended simply because it is common. What stood out most was Cruz's persistence. He kept pressing until he got a direct answer, and that answer confirmed his point. At the end of the exchange, both Cruz and the witness agreed that judges must have a factual basis before making formal findings. That should not be controversial. It is one of the basic principles of the rule of law. Whatever your politics, judges should never sign orders based on assumptions alone. And in this exchange, Ted Cruz made that point clearly and effectively.